My name is Sophie Mercer, and I was 26 years old when my grandmother died, and my parents filed to contest her will on a Tuesday morning without telling me. I found out the way you find out things in small towns. A neighbor called to say she'd seen my father's car outside the courthouse. I was at my desk at the time in the accounting firm where I'd worked for 4 years, reviewing a quarterly audit for a client in Columbus. I set down my pen. I did the math in my head the way accountants do, and the numbers didn't add up to anything good. 3 weeks later, my parents' attorney filed a complaint with the Ohio CPA Board. Professional misconduct. Elder financial exploitation. A licensed accountant who had, the complaint alleged, embedded herself in a dying woman's finances and redirected a $2,800,000 estate into her own name. The complaint cited my license number. It cited my employer. It cited a case number from the probate court. And it was filed, I later learned, the same morning my mother had coffee with her book club, and described me to 4 women she'd known for 30 years as a girl who had always had a problem with money. My badge was in a drawer by noon. My parking spot was someone else's by Friday. This is the story of what my grandmother left behind a clock. Welcome back to Still Standing Stories, where the women who were written off finally get to read the last chapter out loud. If you have ever been the one your family decided was the problem, this story is for you. Subscribe before we go further, because what was on page 4 of my grandmother's trust document is the reason I'm sitting here today. And the reason my parents walked out of a courtroom with nothing. Stay with me. My grandmother's name was Eleanor Mercer. She was 78 years old when she died, and she was the sharpest person I have ever known, which is saying something because I have spent my entire professional life around sharp people. Eleanor had run a bookkeeping service out of a converted carriage house behind her home in Granville, Ohio for 31 years. She did the books for half the small businesses in Licking County, the hardware store, the diner, the family dental practice, the florist. She understood money the way some people understand weather. Not just the current conditions, but the systems underneath, the patterns that told you what was coming 3 days out. She also understood people, which in my experience is rarer. The clock was in her living room. A mahogany mantel clock, 8 inches tall, with a cream face and black Roman numerals, the kind you see in old houses and antique shops and nowhere else. Eleanor wound it every Sunday morning without fail, the same way she made coffee and read the paper and balanced her weekly ledger. The clock was a routine. The clock was a ritual. The clock was, I would eventually learn, something else entirely. I did not know any of this when I was growing up. What I knew was that my grandmother's house had a clock that ticked, and that ticking meant Sunday, and Sunday meant Eleanor's kitchen, and Eleanor's kitchen meant the best biscuits in Ohio and a woman who asked you real questions and listened to the actual answers. I need to tell you about my parents, because you cannot understand what happened in that courthouse without understanding where I came from. My father, Richard Mercer, has run the Mercer Group for 25 years. It is a commercial real estate company, mid-sized, regional, profitable in the way that businesses are profitable when the person running them has been doing it long enough to know every shortcut and every angle. My father is not a bad man. He is a man who has never in his adult life encountered a situation he could not manage, and this has made him over time incapable of recognizing the situations where management is not the right tool. My mother, Diane, runs the administrative side of the Mercer Group. She has done this since before I was born. She is organized, she is competent, and she loves her children with the specific proprietary love of a woman who views everything in her life as an extension of herself, including her children. When I was 19, I told them I wanted to study accounting, not business. My father said accounting was a support function, not a leadership function, and that the Mercer Group needed leadership. My mother said I would understand when I was older. My grandmother, who was at dinner that night, said nothing and helped me clear the plates, and in the kitchen said quietly, "Follow the numbers, Sophie. The numbers always tell the truth." I enrolled at Ohio State that fall. I did not come home for Thanksgiving. By Christmas, we had reached an arrangement. Not peace, exactly, but something that functioned like peace if you didn't look too closely. I came home for holidays. My parents paid my tuition, which was their money and their choice, and which I accepted and which I also understood, without being told, was an account they intended to collect on. I graduated. I passed the CPA exam on my first attempt. I got the job in Columbus, and for 5 years the arrangement held. Then Eleanor got sick. It was her heart. Not a sudden thing. She had known for 2 years that it was getting weaker, and she had managed this information with the same efficiency she brought to everything else: doctors, medication, regular monitoring, and a quiet rearrangement of her affairs that I was not aware of until much later. She told me she was slowing down. She told my parents the same. What she did not tell any of us was that she had been meeting with a trust attorney named Margaret Holt every few months for the past 3 years. I drove to Granville on weekends. Not every weekend. I was working and she was fiercely independent, and she would have been insulted by the suggestion that she needed looking after. But most weekends we sat in her kitchen. We talked. She asked me about my cases, which I described in general terms that preserved confidentiality, but gave her enough to engage with. And she would lean back in her chair and say things like, "Where's the money actually going, though?" Or, "Who benefits if the audit comes back clean?" She was teaching me, I understood later, reviewing, testing whether the years had made me any better at the things she'd been showing me since I was 10 years old. In October, she showed me the clock. We were in the living room a Sunday morning, and she was winding it the way she always wound it, and I said something about how it kept perfect time. She set down the key and looked at it for a moment and said, "There's more to that clock than the time, Sophie." And then she changed the subject, and I filed the statement away in the back of my mind without understanding it. The way you file things that don't quite fit. She died in February, on a Wednesday morning, in her own bed, which was exactly what she wanted. I got the call from her neighbor, not from my parents. They had known since the night before. I found this out later. I drove to Granville and let myself in with the key she had given me years ago, and I walked through the house that smelled like her. Coffee and cedar, and something I will never be able to name, and I sat in the chair by the mantel clock for a long time. The clock was still ticking. I had wound it the Sunday before, because she'd asked me to, her hands not quite steady enough, and it was keeping perfect time. Stay with me, because this is where the story starts moving. My parents arrived 2 hours after I did. My father had a legal pad, my mother had a folder. They walked through Eleanor's house with the specific efficiency of people who had already made a list, and my father made notes about the furniture, and my mother made notes about the silver, and I sat in the chair by the clock and watched them and felt something go cold in my chest. At the funeral, which was 4 days later, my mother held my hand in the front pew and whispered, "We'll need to talk about the estate, Sophie." As a family, she said family the way she said everything, like it was a category she managed. The letter from Margaret Holt's office arrived 10 days after the funeral. All interested parties were invited to attend the reading of the estate plan of Eleanor Jean Mercer. The following Thursday at 9 in the morning, my mother called within the hour. Margaret Holt was 60 years old, with gray hair cut short and the steady, unhurried manner of someone who has been in rooms with grieving families long enough to have no patience for theater. Her office had diplomas and plant and a coffee maker, and nothing else that wasn't necessary. She read without preamble, the estate of Eleanor Jean Mercer, held in the Eleanor Mercer Revocable Trust, consisted of the house on Elm Street, appraised at $520,000, the commercial building downtown, home to Elm Street Flowers and Granville Hardware for the past 18 years, valued at $640,000. Investment accounts totaling $1,490,000, built across 40 years of careful, consistent management. Cash and personal property, $150,000. $2,800,000. Every dollar of it, the house, the building, the accounts, the personal property, to her granddaughter Sophie Elizabeth Mercer, sole beneficiary. To her son Richard and his wife Diane, $15,000 each, and I quote, "With my gratitude for clarifying in 2018 exactly what kind of family we were." The room was very quiet. My father set his legal pad on his knee, very carefully, the way you set something down when your hands need something to do. My mother's face did the thing I had seen it do exactly twice before in my life. The composure stayed, but something behind it shifted, like a painting moved half an inch on its hook. And then my mother smiled at me, warm as a heating pad, and said, "Oh, sweetheart, that's an enormous responsibility. Of course we'll help you manage it properly." I said thank you, and I did not say anything else. In the parking lot, Margaret Holt touched my arm and said, "Your grandmother left some specific instructions. Sophie, Come to my office tomorrow morning, bring nothing. Just yourself. I want to tell you what I found in Margaret's office the next morning, but first I have to tell you what my parents did that night, because the sequence matters. That evening, my mother called my cousin Derek, who is 34 and who has borrowed money from my parents 3 times and paid it back twice. She called my father's sister in Cincinnati. She called, as best I can tell, 7 people in the space of 2 hours. She did not call me. By the time I arrived at Margaret Holt's office at 9 the next morning, the Mercer Group's attorney had already filed a motion in Licking County Probate Court to contest the Eleanor Mercer Trust. Grounds: undue influence, lack of testamentary capacity, and the sentence that would matter most, request for appointment of interim estate managers during the proceedings. Manage it properly. She'd found a way to say it on legal letterhead. Margaret was already at her desk when I arrived. She had a cup of coffee for me and a file folder on the desk between us, and she looked at me the way people look at you when they're about to say something they've been waiting to say for a while. Your grandmother, she said, did not leave this to chance, and she opened the folder. Eleanor Mercer had walked into Margaret Holt's office for the first time in March of 2019. She had been 74 years old, wearing her Sunday coat, and she had said, "My son has made it clear what he values, and I intend to make sure it's useless to him. What do I sign?" Over the next 4 years, Eleanor had built something. The trust itself was structured to survive a contest: independent trustees, capacity documentation, meticulous records of every decision and its rationale. She had seen 2 doctors independently on the same day she signed the final amendment, in January of 2024, and each one had certified her memory, her judgment, and Margaret smiled when she read this part, her complete awareness of all relevant family circumstances. She had never told me any of it. She had, however, told me about the clock. Margaret reached into the folder and set an envelope on the desk. My name on the front in Eleanor's handwriting, below it in smaller letters to be opened after the reading, if they contest. Inside was a single index card, her handwriting, precise and small. "Check the clock, Sophie." The winding key comes out. What's underneath was put there in 2019. "Love, Gran." I went to her house that afternoon. I wound the clock. I removed the key. And underneath the key, in a small recess I had never noticed in 30 years of looking at that clock, was a folded piece of paper. A letter. 1 page dated March 15, 2019. Eleanor's handwriting. I'm not going to tell you everything it said, because some of it is private and belongs only to me, but I will tell you this. She had written down, in her own hand, exactly what she believed my parents would do when she died. The sequence, the moves, the language they would use. She had been right about all of it, and she had written, at the bottom, "If this letter is in a judge's hands, it means they followed the script I wrote for them. I'm sorry, sweetheart. I'm not sorry for what I left you. I am only sorry it cost you something to receive it." I sat on her living room floor for a long time. Then I called Margaret and told her what I had found. Stay with me, because what happened next moved faster than I expected, and the part from the title is coming. Here is what my parents did not know when they filed that motion. Margaret Holt had been an estate attorney for 32 years, and she had seen this particular play before, and Eleanor had spent 4 years making sure she had the right response for every line. Here's what I did not know: the trust contained what Margaret called a no-contest clause. Article 7, 2 paragraphs, buried between the provisions for charitable giving and the terms for the trustees. Any beneficiary who contested the validity of the trust, without probable cause, would forfeit any and all interest granted under it. The $15,000 each, conditional on not contesting. My parents had just forfeited it, but Margaret said, "There's more," and for the first time in our meetings, she looked like a woman who was genuinely looking forward to something. "Your grandmother was very specific about one thing," she said. "There's a document I cannot show you before the hearing. Her instructions. She said the judge gets to read it first. Out loud." She said the out loud part twice, Margaret told me. She was very clear. 3 weeks after the contest was filed, the bad news arrived at my office in an envelope. A formal complaint to the Ohio CPA Board. Professional misconduct, detailed allegations. My license number. My employer's name. I learned later it had been filed the same morning my mother had coffee with her book club. Same morning. She had drafted the complaint and scheduled brunch simultaneously, which I will say is organized in the way that certain very efficient, very cold things are organized. I was called into my supervisor's office at 2 in the afternoon. He was decent about it. He couldn't look at me, which I understood. An accounting firm with an accountant under a financial exploitation investigation is a liability, and he had other clients, and I had known, walking in, what the conversation would be. I handed over my badge, I packed my desk, I drove home to my apartment, and I sat at my kitchen table and I did what accountants do. I made a list: assets, the trust, if it survived, Margaret, a letter and a clock, liabilities, no income, no license, no professional reputation while the board investigated, my parents' attorney, the 6 to 8 months it would take for the board to clear me, if they cleared me. The math was not good. My parents' attorney, a man named Gerald Pruitt, who had done commercial real estate work for the Mercer Group for 20 years, and who knew my father well, sent a settlement offer 2 weeks after the board complaint. It was precise and it was elegant, and it was. I recognized immediately the same kind of thing my grandmother had described on that index card. $400,000. A family settlement. Full withdrawal of the will contest. Full withdrawal of the board complaint in exchange for a payment characterized as an equitable distribution among surviving family members. The letter noted, almost as an aside, that licensing matters tended to resolve themselves when families reconciled. Pay us or the investigation continues. I sat at my kitchen table and I read that letter 4 times. My savings were at $11,000. My rent was due in 3 weeks. I had not told my mother or my father where I lived since I moved to Columbus, and I was grateful for that now in a way I hadn't been before. Then I called Margaret. She was quiet for a long time after I read her the settlement offer. Then she said, "Sophie, your grandmother left instructions for exactly this." She called it the second envelope. "Do you want to know what's in it?" I said yes. She said, "It's a letter to the judge. Eleanor wrote it herself in January of 2024. Notarized, witnessed, sealed. She specified that it is to be read aloud in open court in the event of any challenge to the trust. All of it, to whoever is in the room. She said it to me the way people say things they have been looking forward to saying." I tore up the settlement offer. The evidentiary hearing was set for April in the Licking County Probate Court. Judge Patricia Wren, 62 years old, with the patient, unimpressed manner of someone who has heard every story about family money that exists and invented a few of her own. I want to tell you about walking into that courtroom because the details matter. My parents were at the petitioner's table in their good clothes. My mother had a leather portfolio. My father had his legal pad. Gerald Pruitt was between them, a man who had billed $400 an hour for the Mercer Group for 20 years, and who was very good at his job. I was at the respondent's table with Margaret, who had brought 3 folders, a thermos of coffee, and a sealed envelope from Eleanor. My grandmother was not there, and she was everywhere. Pruitt went first. He was thorough, and he was professional, and he built, over the course of 2 hours, a portrait of me that I recognized in the way you recognize a distorted mirror. The shapes were mine, but the proportions were wrong. A licensed accountant with access to an elderly woman's home and financial history. Present during the last years of her life, named as sole beneficiary in a revised estate plan that significantly altered what her son, her only child, would have received under an earlier version of the will. He did not say that the earlier version was from 2009, before the conversation at dinner when I was 19. He did not say that the revision had happened over 4 years, documented and witnessed and medically certified. He said pattern of access and influence and let the phrase do the work. My mother testified. She was composed and she was warm and she was convincing, and I watched the judge watch her, and the judge's face told me nothing. My father testified. He talked about family unity and his mother's vulnerability and his genuine concern for the integrity of the estate. He did not mention the legal pad. Then it was my turn. I want to be honest about what it felt like to take that stand, because the videos that skip this part are lying to you. My hands were steady. Accountants learn to keep their hands steady. It's almost a professional requirement. But underneath the steady was something that had been building for 15 years, and I had to decide, in that chair, whether to manage it or let it speak. I let it speak. I told them about the dinner when I was 19. I told them about Ohio State and the CPA exam and the job in Columbus and the 5 years of the arrangement that functioned like peace. I told them about driving to Granville on weekends and sitting in Eleanor's kitchen and learning, from a woman who had kept the books for half a county for 30 years, that the numbers always tell the truth. And then I told them about the clock. I described finding the key, the recess underneath, the index card. The letter dated March 2019, a woman of 74 who had just watched her son make his intentions clear and had sat down at her kitchen table and written out, in her precise small handwriting, exactly what she expected to happen after she was gone. I set the letter on the stand in front of me and I read the relevant section aloud into the record, in a voice I kept level, the voice I use when the numbers are bad and the client needs to hear it anyway. She had predicted the contest. She had predicted the board complaint. She had predicted the settlement offer. She had called the amount, not exactly but within range, close enough that Pruitt looked at his notes when I read it. I said, my grandmother was a bookkeeper for 31 years. She understood accounts receivable better than anyone in this county. She also understood that some debts aren't financial. She spent 4 years making sure the ones she owed me were paid, and the ones she didn't owe anyone else were protected. I stepped down. Then Margaret stood and asked the court's permission to introduce the sealed document from Eleanor Mercer per the trust's instructions. Judge Wren said, I'll read it when we get there. We got there 40 minutes later, after Dr. Patricia Nguyen testified about 2 capacity examinations conducted on the same day. Eleanor signed the final amendment, and after a business attorney named Carl Webb testified about the trust's structural integrity, and after 3 of Eleanor's longtime clients testified about her financial acumen, her judgment, and the very specific, very intentional way she ran her affairs, Judge Wren picked up the sealed envelope. The room was quiet. She broke the seal. She unfolded the letter. She put on her reading glasses. And she read to the court from Eleanor Jean Mercer. I have spent 4 years preparing for the possibility that my son and his wife would stand in this room after my death and ask for what I chose not to leave them. I am writing this letter so that the court understands I knew they might, and I planned accordingly. In 2019, my son made clear to me that he viewed my estate as a family asset to be managed collectively, meaning managed by him. When I told him I had other intentions, he suggested, politely, that I might need help making sound decisions. I have 40 years of client records that speak to my decision-making. I would refer the court to Exhibits 7 through 9. I left my estate to my granddaughter, Sophie, because she has spent her life learning to follow the numbers to the truth, even when the truth was inconvenient, and because she was sitting at my table on a Sunday morning telling me about an audit when my son was telling his attorney to find grounds for a guardianship petition. I know what I'm doing. I have always known what I'm doing. If this letter is being read aloud, it means they followed the script I wrote for them. I'm not surprised. I'm not angry. I am, from wherever I am now, watching my granddaughter sit in a courtroom and do the thing she has always done, which is to trust the numbers and let them speak. The numbers are in the exhibits. Judge Wren, the truth is in the clock. Page 4. My mother's smile didn't break. It drained, from the corners of her mouth down, like something unplugged at the source. Because here's what Eleanor had put on page 4, at the bottom of the letter, in the careful small handwriting that I had been reading since I was a child, a table, 2 columns. Dates on the left, on the right, descriptions. 31 entries, from October 2019 through November 2023. Each one documented a conversation she had recorded in a small notebook she kept in her kitchen drawer. Conversations with my father about the estate. Suggestions that she consider revising her plans. Gentle mentions of the Mercer Group's capacity to manage complex assets. A question in September 2022 about whether she had considered a family partnership structure. 31 documented attempts. And at the bottom of the table, in Eleanor's hand, I kept the notebook because I knew they would say there were none. Pruitt asked for a recess. Judge Wren said she would take the matter under submission. 6 weeks later, the ruling came. Petition to invalidate the Eleanor Mercer Trust, denied. The court found 2 independent contemporaneous capacity certifications. 31 documented records of petitioner's own attempts to influence the estate plan, and no evidence whatsoever of undue influence by the beneficiary. The trust stood. Every clause, every bolt Eleanor had tightened over 4 years. Article 7. The no contest clause. The court found the petition had been brought without probable cause. The $15,000 conditional bequests to Richard and Diane Mercer were forfeit. My parents had contested a $3 million estate and left with less than nothing, minus their legal fees, which the court noted it would consider awarding to the trust. In the hallway after, my father found me by the water fountain. He looked older than he had at the funeral. He said, "She always did think 20 moves ahead." I said, 31. I counted. He nodded. He didn't say anything else. He walked to where my mother was waiting, and they left through the main entrance, and I went out through the side door into the April afternoon. The board cleared me 7 weeks after the ruling. The complaint was closed, unsubstantiated. My supervisor called before the official letter arrived. The parking spot was mine again if I wanted it. I told him I'd think about it. I drove to Granville that weekend. I wound the clock. I sat in Eleanor's chair, and I let the ticking be a ticking, without trying to hear anything else in it. Here's where things are now, and I want to be straight with you about all of it. I left the firm, not because of the board complaint. That was cleared, but because the months without the license had given me time to think about what I actually wanted to do with the work I was good at. The Elm Street building has 2 tenants. The florist, who has been there since 2008, and the hardware store, whose owner, a man named Dale, showed up at Eleanor's kitchen every Tuesday for 15 years with a ledger and left 2 hours later with reconciled accounts and considerably better coffee than he made himself. I offered Dale a different kind of arrangement. The building at cost, the bookkeeping on my time, the coffee on me. He cried. He is 71 years old and he has been in that building since before I was born, and he cried. I practiced now out of a small office above the florist. Individuals, small businesses, the occasional estate matter that Margaret refers to me. It is quieter than Columbus, and it is exactly right. My mother sent a letter in June, 4 pages. I read it twice. It contained the word sorry in 2 places and the word unfair in 3, and the ratio told me everything about the accounting system she was still running. I set it on the green table in Eleanor's kitchen, my kitchen now, and I looked at it for a while, and then I filed it where it belongs. My father sent a check, smaller than the settlement offer. No letter, just a check and his handwriting on the memo line. What I should have said at the table when you were 19. I did not cash it, and I did not tear it up. It is in a drawer. I look at it sometimes. The clock is still on the mantel. I wind it every Sunday morning, the same way Eleanor did, and it keeps perfect time. I found the notebook. It was in the kitchen drawer, exactly where she said. 31 entries in her handwriting, dates and details, just like the table on page 4. I read all of them. Some of them made me laugh. One of them, from Christmas 2021, made me sit on the kitchen floor for a while. I keep it wound. I don't plan to stop. I want to tell you about Eleanor's bookkeeping clients because understanding them is understanding her. For 31 years, she sat at her kitchen table every Tuesday and Thursday with whoever needed her, and she kept their books. Not just the numbers, the people behind the numbers. She knew which restaurants were struggling before their owners did. She knew when the hardware store was going to have a record quarter because Dale ordered differently in October. She knew the florist was going to need a line of credit 6 months before the florist knew it herself. And she told her, and the florist got it, and the business survived a difficult spring. She was not a warm woman in the way people mean when they say warm. She was not soft or sentimental. She did not say things were fine when they were not fine. What she was honest in a way that was better than warmth. She told you the truth about your situation with a clarity that meant you could actually do something about it. She told me, when I was 12 years old and had spent my allowance incorrectly and was trying to negotiate with her about a loan, "Sophie, I'll loan you the money." And then she sat down and wrote out the terms on an index card, interest rate and repayment schedule, and handed it to me and said, "Now you decide." I repaid every cent. I still have the card. That is who built the trust that survived my parents' contest. Not luck. Not sentimentality. 31 years of knowing exactly what things were worth and exactly what they cost and writing it down. The Sunday morning she asked me to win the clock. The last time she watched me do it, she said something I didn't understand until the courthouse. She said, "You've always been good at reading the instruments, Sophie. Make sure you read all of them." I thought she meant the clock face. Here's what happened in the weeks between the will reading and the hearing, because it did not happen quietly, and the quiet version would be a lie. Within 48 hours of the reading, the phone tree was working. I knew this because my cousin Derek texted me, Derek who had borrowed money from my parents, and who owed them something for it. And his text said, "Hey, just so you know, your mom is talking to people." I texted back, "I know." He did not reply. My father's sister in Cincinnati called my cell phone, which she had not called in 4 years, to tell me she hoped I would think carefully about what I was doing to the family. I let it go to voicemail. The voicemail said, "Ansley always had a problem with gratitude. She meant me. My name is Sophie. She has called me Ansley for as long as I can remember, and I stopped correcting her somewhere in my 20s. A woman at the grocery store in Granville looked at me for 1 second too long over the cheese display, and I knew my mother's version of events had arrived before I had. Meanwhile, I was trying to understand what I had. Margaret walked me through the trust architecture over 3 meetings in her office, which tasted like coffee and sounded like a very calm explanation of an extremely complicated situation. The trust was, she said, about as well constructed as anything she had seen in 30 years of estate work. Eleanor had thought about every angle. The capacity documentation was the cornerstone. 2 independent physicians, same week as the final signing, both attesting to her memory, her judgment, her awareness of relevant circumstances. The phrase relevant circumstances was Eleanor's. Margaret said she'd insisted on it. Had wanted it in writing that the doctors understood she knew exactly what was going on in her family, not just in her mind. The trustee structure was the second layer. Eleanor had named Margaret as trustee, not a family member, not a bank, a specific person who had known her for 4 years and who had her own professional obligation to act in the trust's interest. This meant that my parents' request for interim estate management had nowhere to land. The trustee was already there, she was already managing. There was nothing to appoint. And then there was the no contest clause, which Margaret explained the way you explain something that was designed to be exactly as simple as it sounds. Contest this? Lose the $15,000, forfeit. Gone. They had contested it anyway? I asked Margaret why, if the clause was there, they would file. She said because they thought the trust itself would fall, and if the trust fell, the clause fell with it. They were betting that undue influence would void the whole document. I said, and they were wrong. She said, your grandmother spent 4 years making sure they would be. The board complaint arrived on a Tuesday. I know it was Tuesday because I had just billed my largest quarterly invoice of the year and was in genuinely good spirits when my supervisor called me into his office. He showed me the document across his desk. He was apologetic in the way of someone who is doing something they don't want to do, but have decided they have to, which is the most professionally painful kind of apology. He said, we have to follow process. He said, I'm sure this will be resolved. He said, I'm sorry, Sophie. I said, I know. I want to tell you about carrying that badge back to his desk, because I think you need to know what it actually cost. I had passed that exam on my first attempt. I had never had a complaint filed against me. I had never had a client contact me after an engagement for any reason, except to say thank you or to send more business. My license number was, in a professional sense, the thing I had built entirely without my parents' help. No referral, no connection, no family name. Just the exam and the years, and my parents had identified it as the one thing the trust couldn't protect, and they had aimed at it precisely. I drove home from the office on a Tuesday afternoon in March, and I sat at my kitchen table, and I did the math. The board investigation would take 6 to 8 months minimum. During that time, I could not practice. My savings were at $11,000. My rent was $1,400 a month. The trust was frozen pending the probate contest, which meant I could not access it even if I had wanted to. The math said, take the settlement. I looked at the settlement letter for a long time. and then I called Margaret and asked about the second envelope. I want to be clear about something, because I think it matters. I did not decide to fight because I was certain I would win. I decided to fight because my grandmother had spent 4 years building a fortress, specifically, so I wouldn't have to surrender, and taking the settlement would have meant telling her, from wherever she was, that it hadn't been worth the effort. Some decisions are not about the math. The night before the hearing, I did something I had not done in a long time. I went to Eleanor's house, my house, technically, though it still felt like hers, and I sat in the chair by the clock and I talked to her. Not praying, not believing in anything specific, just talking, the way you talk in an empty house to someone who is not there anymore. I told her what was happening. I told her about the board complaint and the settlement offer, and the decision to tear it up. I told her about Margaret's face when I said no settlement, which was the face of someone who had been hoping for exactly that answer. I told her I had found the notebook. I had found it 2 days after the reading, in the kitchen drawer, exactly where the index card said it would be. 31 entries, her precise handwriting, dates and details. I had read each one twice. Some of them were businesslike. Date, content, her assessment in parentheses. One entry from a Sunday dinner in December 2022, read, Richard said again that a family structure would protect the assets better. I said the assets were already protected, he smiled. Note, he does not believe me. The last entry was from November 2023, 3 months before she died. My father had called to ask whether she'd given any more thought to the partnership structure. She had said she hadn't. He had said he was only thinking about her well-being. She had written, in her kitchen, afterward, 31. I think that's enough. 31, she had counted. She had kept the count. I sat in her chair and the clock ticked, and I said out loud to the empty room, I counted 2. Gran. And then I wound the clock and went to bed. And in the morning I put on the gray blazer and drove to the courthouse. I want to tell you about the aftermath in more detail, because the tidy version doesn't honor what it actually was. The board letter arrived on a Thursday, official letterhead, formal language. The conclusion I had been waiting 6 weeks to read. Complaint closed, unsubstantiated, no findings of professional misconduct, license in good standing. I read it standing at my kitchen counter in Eleanor's house, and then I set it face down on the counter and went outside and sat on the porch for 20 minutes. Not crying, not celebrating, something quieter than either of those. The accountant's equivalent of a long exhale. My supervisor had called the day before the letter arrived. He said he'd heard from someone at the board office that the matter was closing favorably. He wanted me to know I had a place at the firm when I was ready. He said it genuinely, and I believed him, and I told him I needed some time to think about what came next. What came next was that I sat at Eleanor's kitchen table for 2 weeks and did the calculation I should have done the first time, the one that accounted for all the variables instead of just the salary and the commute. What I wanted to work with numbers, to tell the truth about them, to help people understand their situations before those situations became crises. I had been doing that in Columbus for a corporate firm, which was fine, which was good work, which was not what Eleanor had done for 31 years at this kitchen table. What I had, a building with 2 tenants, a house with a good kitchen table, and a county full of small businesses who had lost their bookkeeper when Eleanor died. The math was not complicated. I put in my notice, I set up the practice. Dale wept, which I had not anticipated and which required me to leave the room for a moment. The florist, whose name is Rosa and who has been in the building since 2008, brought me a pot of tulips on my first day and said, Your grandmother would be so annoyed that she's happy right now, because she always said tulips were impractical. She was right about tulips and wrong about being annoyed. The Sunday table is full again. Margaret comes sometimes with estate questions disguised as coffee. Dale comes with his ledger. 3 of Eleanor's former clients have become my clients, which means that when I sit at this table on a Tuesday afternoon, I'm sitting where she sat, doing what she did, with the people she knew, and the clock is ticking. And the ticking means Tuesday, and Tuesday means the books need balancing. Some inheritance is financial. Some of it is this. I want to tell you about the deposition, because Pruitt was good at his job and the deposition showed it. It was in Margaret's conference room, which is a professional courtesy. Depositions can happen in the opposing attorney's office. But Pruitt had agreed to neutral ground, which I noted because experienced litigators don't make unnecessary concessions. He wanted me comfortable enough to talk. He was 60 thin, with the precise manner of someone who had been doing this long enough to have stopped finding it interesting and started finding it efficient. He had a court reporter and a camera and a printed list of questions that he worked through methodically, without drama. For the first 90 minutes, he asked about facts: my education, my license, my employment history, the nature of my relationship with Eleanor, when I had started coming to Granville on weekends, whether I had ever advised her on financial matters, whether I had ever had access to her accounts. I answered everything. I had nothing to hide, and hiding things when you have nothing to hide is its own kind of problem. Then he shifted. He asked about the trust amendment in 2024. Whether I had known it was being prepared, whether I had discussed it with Eleanor, whether I had ever expressed a preference for how her estate should be distributed. I said no, no, and no. He wrote something on his notepad. Then he said, in the same even voice he'd used for everything else, "Ms. Mercer, were you ever at any point in your professional career the subject of a client complaint?" I said no. He said, "To your knowledge, is there any documentation in any professional record that could be characterized as a finding against you?" I said no. He made another note. He flipped a page on his legal pad. He said, "We'll move on," but I had caught it. The framing. He was building a predicate. If the board complaint, which my parents had filed, which was pending, produced any finding at all, even a minor procedural one, he could come back to that exchange and use it. I told Margaret that evening. She was quiet for a moment, then she said, "That's why we're going to move first." Here is what Margaret had in mind, and it is the thing I want you to understand about what my grandmother built. Eleanor had not just protected the estate, she had anticipated the weapons. The board complaint was ammunition only as long as I was trying to keep it hidden. A secret can be extorted, a disclosed record cannot. Margaret filed a motion the following week attaching the board complaint to the public record of the probate case, with a cover letter explaining that we were voluntarily producing all relevant professional documentation and had nothing to conceal. The ammunition disappeared the moment we put it on the table ourselves. Pruitt had not expected that. I know he hadn't, because his response motion used the word aggressive 3 times in reference to the disclosure. Which is what lawyers write when you do something they were planning to use and you do it first. There's a part of the hearing I haven't told you, and I should tell it because it is the part that cost me the most, and the videos that skip the cost are lying. On the second day, Pruitt called my mother to testify. She wore a blue suit. Her hair was exactly right. She had a tissue in her hand that she used twice, each time at the correct moment, and I watched the judge watch her, and I could not tell what the judge was thinking. My mother testified that she had watched her mother-in-law decline over the past several years. She testified that Eleanor had become increasingly reliant on me and had expressed, on more than one occasion, anxiety about managing her affairs alone. She testified that the revised estate plan, which she had not known about until the reading, had come as a shock, and that the original plan, which had included a provision for the Mercer Group, had reflected Eleanor's true wishes. She was not lying about all of it. That's the thing that made it hard. Eleanor had relied on me, genuinely, in the last year of her life. Eleanor had expressed anxiety about managing her affairs alone. I had heard her say it myself, and what she meant was that her hands weren't steady enough to write the checks, not that her mind wasn't clear. My mother had taken something true and arranged it into a picture of someone who didn't exist. I sat at the respondent's table and I kept my face still. And I thought about the index card in the clock. And I thought about 31 entries in a kitchen notebook, and I thought about a woman who had kept her own ticking appointment with a key every Sunday morning for 11 years. Whether she was sick or well or running out of time. And I thought, she counted them, she counted every one. After my mother stepped down, I watched my father's face. He was looking at the floor. The shadow behind the curtain, the silence in the kitchen. The man who has never in my memory said, "I disagree." He has said, "If you think it's best." He has said, "Whatever makes sense." He has, once, sent a check with a memo line, "Never, I was wrong, never, this isn't right, I do not know what to do with that. I have thought about it since the hearing, and I still don't know. The notebook had his handwriting in some of the entries, her transcriptions of his words, the suggestions about partnership structures and asset management, the polite questions at Sunday dinners that were not actually questions. He did not think he was doing something wrong. That is the truest thing I can say about him. He thought he was being practical, and he has always believed that being practical is the same as being right. My grandmother understood this. She wrote it in the notebook, the entry from December 2022. Richard believes the money is the point. He has never understood that I am the point. One more thing about the clock. In June, 2 months after the ruling, I was winding it on a Sunday morning and I looked more carefully at the recess where the key sat, where the folded paper had been, and I noticed that the recess was deeper than it needed to be for a winding key. I got a flashlight. I looked. There was another piece of paper, folded smaller, tucked underneath where the first one had been. I sat down on the floor. I unfolded it. It was a receipt. Old. The paper was yellowed at the edges. June 1989, from a clock shop in Columbus. 1 mahogany mantel clock, 8 inches cream face, black Roman numerals. On the back, in handwriting I recognized from decades of index cards and client ledgers, but that was younger, less settled than what I knew. Bought this for the new house. Richard says it's impractical. I say we need something that keeps time, honestly. Maybe someday one of us will know why that matters. She bought it when my father was young, when they were still becoming who they would turn out to be, when she did not know yet what would matter or why. She had spent 40 years turning out to be right. I put the receipt in the drawer with my father's check. Sometimes when I look at the drawer, I think about what she meant by honestly. A clock that keeps time honestly doesn't make the time go faster or slower, depending on who's watching. It doesn't round up or round down. It ticks and tells you what it is, every second, for as long as you wind it. My grandmother kept time honestly for 78 years. She kept it in ledgers and notebooks and index cards and a sealed letter to a judge. She kept it in a clock that ticked whether she was alive or not, whether anyone was listening or not, right up until the moment I got there and started listening. The numbers always tell the truth, she said. I wind the clock every Sunday. I keep the count. I need to tell you about the cliffhangers inside the hearing because the hearing was not 1 moment. It was a day and a half, and the day and a half had its own rhythm, and the rhythm matters. The first break was at 11 in the morning on the first day, after Pruitt had spent 2 hours building his portrait of me and the judge had listened to all of it without expression. During the break, Margaret and I stood in the hallway with coffee and she said, "He's better than I expected." I said, "He's right about some of it." She said, "I know. That's why it's effective. The best arguments are the ones with true parts." The second break was after my mother testified. I went to the bathroom and stood at the sink and ran cold water over my wrists, which is something I do when I need to bring myself back to a specific temperature. 4 minutes. Then I dried my hands and went back into the courtroom. The third break was when Pruitt asked for a recess after Eleanor's letter had been read into the record. The judge granted 15 minutes. Pruitt went into the hallway with his co-counsel, and they spoke quietly for a long time. I watched through the window. My father looked at his legal pad. My mother looked at nothing I could identify. Margaret leaned over and said, "They're deciding whether to settle." I said, "Can they settle now?" After the reading, she said, "They can always settle. But the clause has already triggered. They already contested it. The 15,000 is already gone regardless. Now the question is whether to keep fighting for the larger amount or cut their losses." I said, "What do you think they'll do?" She said, "Your grandmother thought they'd fight." She put it in the second notebook. I said, "There's a second notebook?" There was a second notebook. Eleanor had told Margaret about it in January of 2024. It contained, Margaret said, a prediction: they will contest all the way. They have never stopped fighting for anything they believed was theirs. I am counting on it, she was counting on it, because the further they fought, the more the documented record built against them. Every motion, every deposition, every testimony went into the public record. The 31 entries in the first notebook, the 2 doctors, the 4 years of Margaret's meeting logs, the trust structure itself, which got stronger, not weaker, the more Pruitt challenged it. Eleanor had built a trap that got tighter the harder you pushed against it. When Pruitt came back into the courtroom, he said, "We'd like to continue to the evidentiary phase, Your Honor." The judge said, "Of course." And Eleanor, from wherever she was, had been right again. Let me tell you what it felt like to walk out of the courthouse after the ruling. Not the day of the hearing, the day the written ruling came, 6 weeks later, by certified mail to Margaret's office. And she called me at 8 in the morning and read it to me over the phone. I was in Eleanor's kitchen. I had been up since 6, drinking coffee and reading a client's quarterly numbers and watching the light come across the table. When Margaret called, I set down my coffee and I listened. She read the holding, denied with prejudice. She read the finding on capacity. 2 independent certifications, 20 years of treating physician records, 0 medical evidence from petitioners. She read the finding on undue influence. No evidence whatsoever that the beneficiary influenced the estate plan, and abundant evidence that the plan was a response of long-standing to the petitioner's own prior conduct. She read Article 7, the forfeiture, the court's note about fee recovery, and then she said, "Your grandmother won." I said, "We won?" She said, "Sophie, I have been doing this for 32 years. Your grandmother won." We just showed up. I sat at the kitchen table after the call and the clock ticked and the light moved and I thought about 31 entries in a notebook and a receipt and a clock and a woman who bought a mahogany mantel clock in 1989 because she needed something that kept time, honestly. I thought about the index card she left me, the one that said, "Check the clock, Sophie." She had put me in the habit of reading instruments, all the way back to when I was 12, and she handed me a card with an interest rate and said, "Now you decide." She had been teaching me since then to look at the things that other people looked past, to trust the numbers, to keep the count. I looked at the clock, 7:42 in the morning. Exactly right. I picked up my client's quarterly numbers and I went back to work. If your family ever turned love into a ledger and put you on the wrong side of the balance, hear me. The numbers always tell the truth. Sometimes they take years to come out. Sometimes a woman with perfect handwriting and 31 years of patience has to carry them into a courtroom herself. But they come out. There is one last thing I want to say before we're done, and it is the thing I have thought about the most in the months since the ruling. My grandmother spent 4 years building a legal structure to protect what she wanted to leave me. Trustees? Capacity letters? No contest clauses, a sealed letter to a judge. She was thorough, and she was patient, and she was right about everything she predicted. But here's what I think she was actually doing, underneath all of it. She was teaching me, one more time, what the numbers tell you if you read them right. Not the trust documents, those were the mechanism. The lesson was what the documents contained, evidence that one person had paid attention, that someone had written down what she saw for 31 entries, without anyone asking her to, that she had built over decades a record of the truth that was solid enough to survive a court challenge by people who had every incentive to bury it. The numbers always tell the truth, she said. What she meant was, but only if someone keeps the books. She kept the books for 31 years in this county. She kept them for 31 conversations in a kitchen notebook. She kept them for 11 years in a clock that ticked whether she was there or not. And she kept them, finally, in a sealed letter that a judge read out loud in a room full of strangers. On behalf of a woman who had been gone for 2 months and who had, nevertheless, managed to speak last. I keep the books now. Different tables, different clients, the same county, the same kitchen. The clock ticks. I wind it every Sunday. Drop one word in the comments that describes how this story made you feel. Just one. Tell me where you're listening from. I read every comment. Share this with someone who trusted the count when everyone else said it didn't add up. Hit subscribe and I will see you in the next one.